Greetings, everyone. Welcome to our exclusive Global Leading Voices webinar campaign. We are delighted to have you join us here today. Please be informed that if you have any questions during the presentation, you may type them into the question box in your control panel. The presenter will answer your questions at the end of the presentation accordingly. Now, without further ado, we will turn the time over to our presenter, who will begin shortly.
Good morning, everyone. Welcome to the latest PECB webinar. Today's topic is data privacy trends in 2021 and compliance with new, modifying, and emerging regulations. I'm very happy to be speaking today with Peter Geelen as well. And I'll just let Peter introduce himself first.
Thanks, Tony. Yeah, right. I've been passing a few interesting privacy sessions, and with the suggestion of adding a more global approach on that one, I think is a perfect add-on with the knowledge of Tony to dive into the global impact on privacy legislation. I will take care of the European side, and Tony will share some quite interesting insights on the US and Canadian part of the story. So there we go, Tony, it's yours.
Thank you, Peter. I've done a few other webinars for PECB, and this one certainly strikes close to home right now. We see a lot of interesting events and activities going on the privacy side of things, and we'll be talking through some of that information today with all of you. I have a background in privacy and cybersecurity as well, and have worked in IT, of course, over the years. So this topic is of great interest to me as well. So for today, we're looking to talk about data privacy and data protection generally. We'll do a brief definition sharing because it's always good to have a baseline. We'll talk about the current status in these areas globally and some new and updated privacy legislations. There's so much happening right now globally in privacy and data protection that it's amazing, but it's all good. Lots to watch out for, though, with regards to your organization and remaining compliant, of course. We'll look at some commonalities between the legislations and impacts of the various current and emerging and modifying legislations globally, and look at some trends as well, and then have a Q&A session at the end. So, Peter, do you want to have any opening remarks on your side?
Yeah, as we have been doing over the year, last year, also with the privacy and the information security sessions, we are taking care of it. That also the Q&A. So yeah, now we're talking about this, and certainly with Tony on my side, it's pretty difficult to compress everything in 1 hour session. You will see that we were recording the session. You will get access also via SlideShare, access to the presentation deck, but there is more of it. And we'll take care of that one by answering to all the questions as much as possible. So the first ones will be answered within the time frame, but if there are other questions, we'll take care of answering them offline and posting the questions. So we published a collaterals page, and you will see in the next few slides that we have published actually also the background. As soon as the session recording is available, including with the slide deck, we'll make sure that we link to these pages and the Q&A. But also a very important, Tony will talk about quite some legislations also on the American continent, the large continent, including Mexico, Canada, the US side. There's a lot of things to do and to investigate. So we will take care also of publishing these links so you can start digging into it later on. And that's exactly what will be available on the next slide. So go ahead, Tony.
Thanks, Peter. Great summary. So here's some of the information that Peter was referring to for finding past webinar information on the PECB website, and then also finding information on Q&A and collaterals and so on. Peter's made sure he's put extra effort in here to make this information available to everyone attending today. The presentation recording will be at PECB's website under past webinars. You may have also seen some content that is shared on LinkedIn and on YouTube as well. And then there's some reference and information Q&A for this session as well in a specific location on LinkedIn, which you can find under Peter's well-orchestrated link here. Anything else on that one, Peter?
No, we can start. I think we got a lot of content, so can fire up.
Great. So we have a short definition, and this one is one that's commonly available through Wikipedia. And I've highlighted key terms within this definition: collection and dissemination of data technology, and then, of course, the relationship between those actions of collection and dissemination, and the public expectation of privacy, which includes legal and political issues surrounding this. And I think we're all very much aware of this, and I know Peter can speak to this as well, that privacy legislation affects business, it affects legal processes, it affects individuals. It has a very penetrating effect in the world today, and it's increasing, as we'll talk about through this presentation. There is a little bit missing from this definition, but we'll talk about that as we go through the next couple of slides. And Peter.
It's quite important to understand that depending on the region or even the country or even in the provinces per country, that you understand what privacy or data protection is. And certainly in the GDPR side, so now looking at the European part of that one, is that GDPR is not referring to privacy as such, but GDPR as general data protection regulation is actually talking about the protection of your personal data and literally your personal attributes. Of course, first of all, first name, last name, address data, but even including email addresses. And that's a very important interpretation, because, for example, we will talk about it later on. If you look at the other side of the ocean to that one on the US and the Canadian side of that one, is that PII, or personally identifiable information, might be interpreted slightly different, and certainly for privacy. And what you will see, for example, that in the European context, privacy is rather considered as your personal space. And what you will see also in the next slide is that privacy in that perspective is considered as the right to do what you want, or even some context you will see it as the right to be left alone. And that's quite important because it interprets some of the legislation differently. And so you certainly, if you get into that kind of space or from a professional perspective, you need to take care of different legislations, be aware of this perspective. And at the end of the presentation today, we will discover some hot topics on that one. For example, Clubhouse, which is very active right now for the last few days. The mix of privacy and personal data comes very close to that one. So there's a very thin line between both of them, or even in some of the cases, the thin line is gone. So that's very important to know. And this is exactly what we want to point out of here, is make sure you understand what data privacy, what privacy is, and what data protection is. Right. Good.
Yeah, very good point. In North America, there's a huge distinction between personal health information and personal data, for example. And in addition to that, we're seeing changes in legislations, which we'll talk about on this side of the ocean, where we're seeing things like email addresses now becoming part of that personal data definition, especially in places like New York and California. And we'll see examples of that where there's some overlap happening on that definition.
Yeah, this is exactly what I mentioned. There's also one important thing. So if you look into GDPR itself, we will discover later on that GDPR is not isolated to the European section or European regional or geography, actually, to be honest. But also important, it does make a reference to another part of legislation, which is the e-communications directive, and we will explain later on what exactly the difference is in that one. But first of all, GDPR is not standalone. It impacts other interpretations or other activities like professional activity services, direct marketing, also e-communications, including email. if you send email to customers or prospects. So there's a very tight link between the GDPR and privacy, other regulations, but also internationally. So that's what the importance is of this session. And I think for the next slide, Tony gives a very good overview, and this is also very important to see that there is a lot of legislation. I think that Tony can explain a bit what you need to look at, and it's a very nice slide. By the way, you will also see that in the publication of the slide deck, there are some interesting links, so you can consult this information. We have provided the link later on, so you can access it.
Yeah, and this is from the UN Conference on Trade and Development on their website. It isn't 100% up to date, and it's difficult to maintain any compendium of information like this with regards to legislation globally. And I would say that it focuses mostly, and rightly so, I guess, on trade and development relevant kind of legislations. And there's lots of others that affect privacy legislations and that you can stumble across in your daily work, even as an organization globally, that aren't covered in sites like this. So as Peter alluded to, we have other links available, and what you really need to do is take a link like this one from the UN and cross-reference it against other information sources to get a complete picture of privacy legislations globally. I have a client here in my part of Canada, actually on the east coast of Canada, that has customers who live in the Middle East, who live in Europe, who live in Asia, a couple of clients in Russia, clients in the US, and clients in South America. They're a small insurance company, but their clients live in those other locations, and their clients provide personal contact information and other corporate information to this insurance company, and they store it here in Canada. When I did a privacy impact assessment for them, of course, this map was very relevant for them because it included a lot of legislations that they had to be abiding by when handling their clients' information. But as you can see on the map, 60% is estimated on the UN, by the UN, 60% of countries have legislation. When you look at that though, some of that legislation is already being rebuilt or reinvented or augmented with stronger measures or better language in the content of the legislation. So it's a very much evolving landscape when it comes to privacy legislations globally. 10% of countries have draft legislation, 19% with none, and then 5 countries from which 5% of countries with no data provided. It doesn't mean they don't have legislation or they're not working on it, just means nothing was provided as yet in this survey by the UN. And this is an interactive map. When you go to this website, you can actually select regions, you can select a specific country, you can drill down on legislation groupings. It's quite well done as far as the data collection.
It's quite important to know that if you interpret this map and you understand why privacy or data protection law is there, actually it's finding the right balance between doing business and protecting your data. So in many cases, and that's literally also mentioned, for example, in the GDPR, is this legislation or regulation actually is there to protect the business and to enable businesses to do their jobs. So while many people will feel or will sense that data protection or privacy laws will implement some regulations and limitations, the purpose of it actually is to enable these transfers of data. And it's quite important to know that certainly in the current era of internet, while we're experiencing the freedom of internet now for already more than a decade, but it's quite important to know that also now with internet and the free flow of data, you will not have privacy or you will not have data protection without cybersecurity. Right? You can have the other way around. So you can have cybersecurity, which means a safe company, safe internet, safe infrastructure without the need of data protection. And many companies struggle with that interpretation because they think about cybersecurity in protecting their company. But this is exactly also one of the things you need to look in with GDPR. The slightest chance that you have that you're actually treating personal data, you need to have a look at this legislation, and it's exactly as Tony mentioned in the previous slide, it's quite difficult to make that swap or to make that shift into data protection and privacy protection. We will see later on there is a bit more impact because also legislation is moving very fast, and in that sense we will explain also what Europe is planning to do or will be happening actually in the next few weeks, if not months, for 2021. And also on the other side of the ocean in the US and the Canadian part, there's a lot of things moving, and we will quickly touch on the previous session, for example, CMMC, the Cybersecurity Maturity Certification. So there's a lot of things moving in the era of cybersecurity. So you cannot decouple or disconnect privacy and data protection from cybersecurity. Be aware of that one. So that means that you not only need to look at the privacy and data protection regulation, but also have a look at cybersecurity regulations, and sometimes also you need to plan for certification. Some cases, for example, if you want to handle or want to work with the US government, you probably will be forced into some level of mandatory security.
Absolutely right. Absolutely right. So privacy and data protection versus enterprise security. Do you want to talk about this one too, Peter?
Yes, it's exactly what I mentioned, is that lots of companies think that they need to protect themselves, and it's correct. So meaning you're talking about finance operations, products, services, but simply by the fact that in many of these cases, it's about people, or at least people as a contact that are involved in this kind of operations, you're almost dragged into it, that you also need to think about privacy and data protection. And I just saw last week, for example, in Belgium, that a lot of small enterprises still have that mindset of enterprise security, meaning protecting their company, and they still struggle to fit in the story or fit in the protection for privacy and data protection. And while we will see that lots of large enterprises, certainly operating on a global scale, do have cookie protection, who do have a cookie platform, do have a data protection privacy, it's not always the case. And that's where you need to make sure that you understand what the differences is in privacy and data protection. And as we explained also in the previous sessions, and this is exactly the link with the series of webinars we did with PECB, where you will see, for example, enterprise security is rather referred to as ISO 27001, so the information security protection. It's not mentioning people's data. It's not mentioning the sensitive data, while the new ISO standard, ISO 27701, which is also called PIMS, is exactly matching both of these worlds, actually, to make sure that you don't make any mistakes, or at least you know how to handle this. And this will require you to implement some additional functionality and features, like, for example, a register or incident or data breach management system. So it's quite important to know the differences and where exactly your obligations are set for this one. Also very important, it's not because you do not handle personal or sensitive data that the impact is less. You have seen quite some data breaches, also with ransomware. A lot of these victims have seen that their data were actually published on the internet, and some of them were actually end of business. So be aware that even if you leak or if you lose enterprise data, that the impact for the company is as bad as leaking personal data. But the only small difference is that we will explain also in the next slides, is that if you leak personal data, the subjects or the persons that are impacted by this can go to court or can contact your data protection authority and claim fees and so on. So there's a lot of impact on that one, and that's exactly also the proposition of Tony we will discuss later on, is what is the impact of these data breaches. And we will see in the news there are some quite interesting websites where you can see the effect of the fees and so on, and also the fines that are very prominent available, that these kind of leakage of data leaks will impact your company heavily, right?
All right, so we're going to talk through some examples now. I do, of course, a lot of work on this side of the ocean, but also have customers, as I've mentioned, that have impacts from privacy legislations globally. And in North America, in Canada specifically, we have an act that's a federal act, federal legislation called PIPEDA. Personal Information Protection and Electronic Documents Act, which is getting updated as we speak. There's new legislation being run through our parliament, and that legislation is going to update this and add a lot more teeth and a lot more specific controls and specific guidance to the protection of personal or private data. The one thing that this act focuses on, though, is personal or personally identifiable information as opposed to personal health information. In Canada, as is the case in a lot of countries, within Canada, there's separate provincial governments that run provinces like Ontario and Quebec and Nova Scotia. And these provincial governments have jurisdiction over any acts or laws within the boundaries of their province. They're part of Canada. So this national federal act on privacy is augmented by provincial acts and legislations. Typically, what will happen is a province will take this federal act and they'll interpret it and write a provincial version of that. In many cases, though, they also add a second set of laws or legislation that govern specifics around personal health information. So any of your health data from care providers, hospitals, doctors, whatever it is, whatever entity might collect or maintain your personal health information. There is similar principles in PEPEDA that we also see in things like GDPR and other privacy acts legislation globally, like the right to access your information, the right to correct it, the right to be informed of its collection, use, purpose, all of those things, and the right to opt in and opt out. The place where this act kind of wasn't strong enough was on enforcement and on managing private sector. It is dedicated to private sector in its definition, but really in its application, this act is focused on, more focused, I would say, on larger organizations or federal government. It does specifically state you have to appropriately protect personal information. And at the bottom, as you can see, there is a focus as well with the application of this act with regards to cross-border flow of data. Within each province as well, each province with its own privacy legislation has specific statements in almost every province around that movement of data outside of the province, and that it has to be controlled, managed, disclosed. It's especially sensitive when it comes to moving across international borders, even to the US. Fines for non-compliance can be up to $100,000 Canadian under this act. Plus, they do publish when there's violations or data breaches of the act. Canada also has a dedicated anti-spam legislation. This one is a bit stiffer on the violations side, $1 million Canadian fine per violation. So if you're an organization, you've had 10 violations that day, there's $10 million that you could be paying at a maximum. So it has a hefty price tag on it when you violate it. You have to include within your emails or your mechanism for contacting clients, you have to include an unsubscribe option each time. And even today, even though this castle law has been in place for a little over 6 years now, even today I've seen clients who send out emails to their customers thinking they're allowed to, but without any unsubscribe mechanism and without following castle guidance. And they run a huge risk there, of course, if one person decides to complain. Complaints under these laws are typically funneled up through the Privacy Commissioner's office in Ottawa, or you could be funneling your complaints through a provincial version of that Privacy Commissioner's office. Each province maintains their own Privacy Commissioner as well. This is Canada's breakdown by province and territory. So you can see there's lots of opportunity for interpretation of privacy laws and the handling of personal information. Oh, sorry, that went back. In some cases as well, with these privacy laws, the province may decide that the federal law isn't strong enough and they may augment it quite a bit. Quebec is an example, as well as British Columbia, where the privacy laws are more stringent. For places like the province of Nova Scotia on the far east coast of Canada, their focus is really around not just personal information, but also health information and its movement. They're very, very focused on the movement of data. Apologies, my slide was jumping. There we go. So in Canada, for sure, as in a lot of locations globally, it's always good to be familiar not just with federal acts and legislations, but also with regional or jurisdictional acts and legislations as well. The USA has some federal guidance as well. They focus on electronic signatures and Global National Commerce Act. This enables the use of electronic validation of actual forms or e-data. They also focus on a federal level of control or management of personal health information. HIPAA is a very robust set of laws that are applied across the US that protects your health information and carries some seemingly small penalties. However, as has been reported many, many times with HIPAA, violations are typically in the thousands or tens of thousands of records at one time, and you would be paying minimum of $100 US up to $50,000 US per record violation if you had a breach or a ransomware attack or any kind of unauthorized disclosure of personal health information or personal health records. Just like Canada, the USA also has individual privacy controls and acts and legislations by state. A couple of examples here, and this is only two we've talked about in previous presentations briefly, but the California one was just updated. I think it was 3 months ago, they updated it, and it's more robust now, but the penalties are quite hefty for violating it. The thing with the Consumer Act, Privacy Act in California is that it tells you you have to apply appropriate measures and appropriate privacy programs within your organization. So there's a bit of leeway for interpretation. It's always recommended you err on the side of extreme caution when you're dealing with doing business in California with regards to any kind of personal private information you might handle, and go the extra mile to make your privacy program, your privacy processes very robust, so that it can't be interpreted as being not enough effort, I guess, put into protecting the data. But the penalty, as you notice in California, this particular law applies to people or organizations that have gross revenues in excess of $25 million US, or if they have 50,000 or more personal records for people who reside in California, or they earn 1/2 or more of its revenue from selling personal information. So there's 3 different ways you can have this act applied to you. So again, you have to really pay attention to the acts if you're going to do business in California. Make sure you understand if this act applies to you, and if it does, how you're going to address it to avoid penalties. New York Shield Act as well. This is a similar measure of protection for consumers in New York State. And New York State, just like California, has made it clear that they don't care where your company is based out of. You can be based out of Brazil, you can be based out of London, UK, doesn't matter. This law is going to apply to you if you're collecting any personal information for residents of those states. In Central and South America, Mexico has a federal law. Chile has a law as well, and Chile's is being updated. Brazil has a federal level law, and it's being updated as well, and its enforcement won't begin until August of this year, which is good to know. It's good that they've gotten to this stage, and hopefully nothing else will slow this one down, because this is actually very similar to GDPR, and they're looking for specifics to be in place in each organization. And they do have a history of enforcement with regards to privacy that you can actually look up through a few websites. So they have experience applying it. There's other countries in Central and South America that have either implemented privacy laws or acts, they have them in draft form, or they're in progress. but there's a few locations that are kind of surprising that don't have anything. Some locations in the Caribbean and South America and Central America have no privacy laws at all. One that always jumps out at me is Puerto Rico, since it is a part of the United States. It's not a state on its own, but it is a part of the United States. It's a protectorate of the states, but it has no privacy laws at all.
And that's a very interesting story, Tony, because that's exactly the point. What we have seen in the last few years is that by these driving companies or regions, US, Canada, and Europe, we see actually a lot of synchronization of these privacy laws. For the reason of experience, we have been focusing on the main regions, US, Canada, Europe, to discuss this interpretation of privacy and data protection laws. But we see in other regions, also in APEC, lots of things moving, and lots of these new laws or updates are learning from each other or taking parts of the interpretations and reassemble them to be applicable also on the regions. So it's very important to know that lots of things are moving. I just realized that we actually have forgotten one link between the previous slide and this one, is the implementation actually of the agreements between Canada and US and Europe. And just a few weeks ago, months ago, we had quite an interesting case, and which is now called the Schrems 2, that actually has attacked the data transfer between US and Europe, which is called the Privacy Shield, and was precedented by the Safe Harbor, also known as the Facebook case. We did not include it yet actually in this slide deck, but I will add it also to the collaterals page, because lots of things have been moving in that sense. There's a principle that is called the adequacy decisions in Europe, then that allows actually to transfer your data to other regions if there is an agreement. And there has been for a long time between the US and Europe, but due to the Schrems case, actually this Safe Harbor and Privacy Shield decisions have been attacked and decided as not valid anymore, and which has quite a large impact also on companies, how they adopt or how they adapt themselves and apply the rules in that sense, which is not always easy. As Tony mentioned, it's moving very fast in that sense. Before we go into the European side, I wanted to explain a bit about the way that Europe handles these legislations, and there are two main distinctions actually in the laws and the application of the laws. First of all, is a regulation, which is, for example, GDPR is a regulation, and actually is a European law which all applies to all member states. Still, the member states do have the authority to adopt that law or to add laws in their own national region for that one, but by default it's implemented. And one of the typical examples I can provide to you is the interpretation of youth and what age is considered as applicable for considering a person as not youth anymore, and when they can make their own decision, or there must be a parental decision, for example, on that one. So the age of 13 can be decided differently for some regions. And also there are some articles also in the GDPR that allow the countries, for example, to take different decisions. For example, how does GDPR apply to the government itself, right? By default, for example, GDPR says, well, dear government, the fines do not apply to governmental organization, but you can decide how to do so. For example, in Belgium, there is no fine that is applied to the government itself, and that means actually there are some different ways. Actually, if you have a data breach, for example, the government cannot fine itself in that sense, and that means also there are some other techniques. If you're a victim of these data breaches as a subject, you need to take different ways actually to get refunds or to get your payment back as a subject. The second way that you can decide on legislation is called a directive, and this is very important to know because, for example, as also explained in a few slides back in the Canada, for example, you have that legislation on e-communications that exists also in Europe, which is called the e-privacy, but that's a directive. So how do you handle spam? How do you handle e-communications in the European area is a directive. That means that actually it's a guidance from European level, but the EU countries, so the member states, must adopt legislation to make it applicable to their state. And that means that also that there is lots of more availability or flexibility for the countries how to interpret this legislation in that sense. And that's exactly also one of the things that you will see popping up also in the discussions is how to tune that for national legislation. So you can go to the next slide, Tony. Again, GDPR is about data protection, so your attributes, your name, your first name, last name, email address. So it's not about privacy, while that lots of articles will mention GDPR as privacy legislation. It's by the letter of the law, it's not. It's not deciding what you can do or cannot do at home. And so on. So what the decisions you make to do at home, if you're free and you want to move around, it's not deciding that one. It's literally only discussing the data protection of your attributes and how actually companies or other data control, as it is defined in GDPR, are handling your data. And as mentioned, it's regulation, so it's a law on European level. There's not a lot of flexibility for the companies and the member states to implement it. They can tune a bit depending on how they work. And second thing, very important, also the GDPR goes together with other legislation, and we will discuss that later on. So you can take to the next slide, Tony. And then we have a few legislation that actually are next to the GDPR, and e-communications and e-commerce is a very important one, and e-privacy directive, which is now in review, which already has suffered from a lengthy discussion. But they go together with GDPR, and that's exactly what the European Commission and the European Parliament is discussing right now, is how to fit that e-privacy directive together with GDPR to make sure actually that the regulations and the decisions in both legislations are matched together. So for example, e-privacy is all about e-communications, and you have seen Tony discussing this also in the US and the Canadian side. Is exactly the same thing also in Europe. How do you handle this data, and how do you do direct marketing and commerce actually on electronic way, is exactly the same discussion. So there's no surprise in that sense that Europe is having the same issues and discussions as what US and Canada is doing. But also very important, if you move on to the next few slides, Tony, there's other legislation on this one. It's very important to know that we also have some other directives and legislations coming up. The existing directive is NIS, is actually a directive which protects from a cybersecurity point of view public and critical infrastructure. Critical infrastructure meaning waterways, electricity provision, road traffic control, making sure that all the critical infrastructure which we all need actually to make our life is protected from cyber attacks. Already since a few years available, which required also the member states to implement local legislation. Now NIS version 2 is coming up, so with the lessons learned, probably next year or next 2 years, probably there will be a new version on that one coming up, and it's all about cybersecurity, as I mentioned before in the presentation. Cybersecurity and privacy and data protection cannot be unlinked, so it's very important to know the impact on that one. Another one has got an active, or will be active this year, is called the Cyber Act, and that's actually a sort of twin of the GDPR, is a regulation which will decide actually on the certification level of products, services, and people actually to support actually the NIS in this case. And you will see that very likely the same way as that America or US is handling the cyber certification, which we discussed in previous session. with the CMMC. The Cyber Act will do the same thing, and the point here is that lots of national governments will use that Cyber Act to make sure that the products they buy or the people they work with or the platforms they work with will have a minimum security level, specifically cybersecurity in this case. So the Cyber Act will make a change also on that one, how we will look at in the near future to security and more specifically cybersecurity. And as mentioned, we will also see that there's some impact also in data protection in that sense. Good. You can go to the next slide, Tony.
So some changes coming up, and I guess to knit back to something that Peter mentioned as well, in North America, we also have, of course, the NIST structure for cybersecurity. NIST is a set of guidance out of the US, and it's also got a fairly active and growing section for privacy and data protection and infrastructure protection as well. Those are typically broken out on this side of the water. They break out infrastructure protection as a separate entity, and there's whole sets of guidance around that, like around SCADA systems and SCADA security and ICS systems and IoT and all of that, but there is overlap for certain. In Canada, Canada's taking a step to unfortunately use the exact same abbreviation that California is using for their Privacy Protection Act for consumers, the CCPA. Canada's also building a thing called the CCPA, and remarkably enough, the government states that it's going to be stronger than California's CCPA. So it almost sounds like a bit of competition to see who can outprotect privacy or private data. This is going to be an enhancement to existing legislation. It has a tribunal established, kind of like a commissioner office or commissioner's group. And the goal of this is to try to make sure every organization that has consumer information maintains a structured privacy program, that they've obtained meaningful consent. So it's not enough now to just say, yeah, we said on the page, we're going to use your data. That's enough, or they click OK. That isn't enough anymore. With this new act, they want meaningful consent. So you have to check a box saying, yes, I agree. So there's no gray area when it comes to consent anymore. De-identified data is also covered. De-identified data, as you probably are aware, is information that may not be tied directly to you, but it's your data, and they've just removed your name from it, or your identifying information from it. But that's still covered under this new act. The handling of that information, how it's de-identified, how it's utilized afterwards, that's all part of this new act. So they're going an extra step with the data. There's a right to erasure. Here it's called erasure instead of forgot, or right to be forgotten. So you do have a right under this new act to request your data be erased and never used again. And there's an enhanced enforcement component, which includes even regional enforcement entities to help make sure this is actioned all the time. And they specifically state that private lawsuits are enabled through this act as well. So much like the States, where you get into litigations, if you feel like you've been wronged by a company, that sort of thing can happen with regards to privacy violations in Canada under this act. So it's a new world for Canada to get that kind of thing mentioned in a law of any sort. Third-party service providers are also in scope, so it's no longer just you or your organization, it's whoever you're doing business with as well. You have to make sure you have a complete supply chain, secure supply chain for consumer privacy, all the way up to your third-party service providers. Penalties can be quite hefty, as you see at the bottom. 3% of your global revenue, or $10 million Canadian, or possibly 5% of your global revenue, or $25 million Canadian, for serious breaches. The definition for serious breaches is still being worked on, but these are not inconsiderable fines. Over to
Yeah,
Europe, GDPR.
yeah, we're matching up a few of the things we discussed already, but I rather would move on to the next slide, because actually the next section is discussing the commonalities, and we will discuss the fines that we will discuss. It's pretty similar, and it's nice to see that pretty much the impact of the fines in US, Canada, and some other regions are pretty similar in that sense. So I will discuss the details a bit more on the fines again later on, Tony. So I rather leave it over to you to discuss pretty much some of the common features, and we will compare a few of them. Right.
Sure thing. So privacy officers obviously are important to have in your organization. Everyone's asking for them now. All the legislations are looking for this to happen. Penalties, they're not small, as you've seen in some of these examples, and they can also carry the penalty, of course, of publicly having your name published, the name and shame concept, where you're going to have someone notify an authority that their data was breached while it was in your custody, and then that information becomes public information. Privacy programs should be in place, of course. That includes breach management, includes privacy policies, all the things you think should be in a good privacy program. And breach management notification is often broken out as a separate item in legislation today on purpose, so that you've done appropriate breach management and appropriate notification when and as required. Consent is also a big thing that's become far more relevant and a far more stringent requirement in legislations globally. And that publishing at the bottom of infractions or violations is becoming more common as well, the name and shame approach. So we talked about this one already. So GDPR.
Yeah, it's pretty similar, but I think just as a bit of a repetition of previous sessions, please remember what the core activities and the core decisions and the principles of legitimacy actually in GDPR is covered in Article 5 and 6. As Tony mentioned, consent is just one of them, and we've seen in the past a few years, and certainly with the launch of GDPR, lots of attention has been attracted to the consent, but in essence, there are 4 more important ways or reasons why you need to treat or handle the privacy or actually personal data in that sense. And last but not least, and this is quite hot also right now, is legitimate interest. Actually, that's where the data controller or the company makes the decisions to handle the data. And certainly with this e-privacy and marketing and direct marketing stuff, this has been pretty much under the radar until now, and we see lots of countries in the European region still acting right now on this legitimate interest and direct marketing. So it's a very hot topic, and we will discuss it later on also at the end of the session. There's a huge conflict in how the companies handle the data. If they make the decision to send you a mail or to use that for direct marketing, you enter in a sort of conflict area in that sense. And we see a lot of decisions right now where the DPAs spend some fines actually on not really legitimate interest or the wrong use actually of the legitimate interest. And to link up with the previous slide of Tony also, we see some sample cases also where the name and shame, so the publication of these records without any fines, is also used actually to publish the violation that the company have been doing in that sense. So there's not always large fines being applied, but also the fact that the company got into the news, and some of the cases the companies were not successful in keeping their name out of the cases because it's so exemplary for that one, for the cases, that even these companies could not just simply be anonymous in the court cases in that sense. So we see a balance here, and we will discuss also later on the fine, so we can move on to the next slide, Tony. Is that the application of these principles is very important to know, and that's where lots of companies, and certainly the smaller companies, have a lot of issues actually since a few years to implement GDPR correctly. And again, these principles are applied also in other legislation. So the data protection by default and the data protection by design means that you need to build in that security or data protection into your systems. A lot of companies who are running their infrastructure already for quite a few years have quite some issues in updating their infrastructure to do so. Also, we see more and more joint controllers. That means that companies are jointly handling the data. And that poses quite some issues also in relation to reporting it to the subjects in that sense. And this is also one of the battle areas where we'll see is how you handle data, how you respond to the subjects in that sense. Lots of companies are actually required to have a record of processing, which is also called a processing register, which is not that easy to maintain. For larger companies, yes, but smaller companies have quite some difficulty to get it done. And certainly in case of a data breach, how you handle that one, including notifying the data protection authority, having an incident register, having incident management procedure is not an easy task for lots of companies. So it's quite important. And also securing your processing activities, including cybersecurity, is quite a difficult task. And there are quite some results and analysis and surveys actually that show that lots of companies and we're talking about more than 50% of the companies have issues actually to set up the proper GDPR processing activities. You can go to the next one, Tony. And also important one that's also mentioned by Tony in the commonalities actually in the legislations is obligation to have a data protection officer or a privacy officer or chief privacy officer, what's in a name. There's quite a distinct part of the GDPR that actually handles this this function. It's very important. There are some strict guidelines when it's mandatory to have one, but it's always best that as soon as you have some large-scale operations or a large volume of data working of processing in your company, that you should also consider to have a data protection officer more in an advisory function, but can be wise to have that function created or someone available for that one. But by the way, it can also be an external consultant to helping you out on this one. One of the largest mistakes I also mentioned at the end of this slide is that companies make is that making the data protection officer responsible for the data processing tasks. It's not, and certainly not under GDPR. It's very important that it's an advisory function. The main accountability and responsibility stays within the company, not at the DPO level. And this is an important thing for lots of companies to make sure that actually that segregation of duty is being implemented. You can go to the next slide, Tony. And this one, of course, is well known. We discussed it in the previous sections, previous webinars, so I'm not going too far in detail on this one, but have a look at the numbers. It's well known, but the interesting part of this session of today is that these numbers in fines are pretty much the same in lots of other countries, and there's a clear distinction in major issues and minor issues. Minor issues meaning that if you some of the applications within GDPR who do not touch directly or at large scales on the subjects, you get into a 2% or a 10 million fine, depending on whatever is the biggest, or 4%, or the 20 million euro fine actually is if there is an indirect impact on the subject's rights, you can get into that large scale. And you see that actually the number of fines here, or the value of the fines, is pretty similar as what Tony has discussed earlier on. Right, we can go to the next slide. If you want to see how these fines are working and what's the impact right now, have a look at Google or Bing or whatever, and look for enforcement tracker or GDPR fines tracker. I just gave a few of them. You can find a lot more, but certainly the enforcement tracker, the first one I mentioned over here, is quite interesting. You will see actually a lively follow-up actually on the fines that are being tracked by the data protection authorities all over Europe. So it's quite interesting to see. And even Belgium, as one of the smaller countries in this area, has been quite active, although that the Belgian DPA has taken position not to go for the maximum fines. They have still had some interesting cases, and just for your example, one of the cases is a sort of company that actually collected data from fresh mothers that have just freshly had their babies actually in the hospital, and they send over a sort of commercial package to them. But it looked like that this company was not respecting the rules of the game actually, and they ended up with a 50,000 fine, 50,000 euro fine actually, because of actually mishandling this mother's data and their children's data actually for doing direct marketing, and they sold over actually their privacy or data protection personal data to other companies, which gave quite a large impact of the subject impacted on that one. Good. Go for the next one, Tony. Pretty much similar. Be aware that nowadays, and that's exactly also what Tony showed, is the changes in laws are giving more power to the subject. The fines are going up. The impact and the power that subjects have is very important. And the other side of the balance is that companies, data controllers in this case, need to balance their rights in doing business versus the subject rights, and how to look at it, and of course their position against the government and against their commercial interest to handle that data to do business is a conflict area that gets very hot right now, and lots of decisions and fines are based actually because of this position in that one, and selling data for direct marketing is one of the next battles that will come up probably in lots of court cases up to now, right? Go for the next one, Tony. Good. We're pretty much to the end of the session. Just a few items I wanted to discuss here, or actually put in the air. Actually, it's might be another topic for next session, but be aware that also cybercrime is increasing. We've seen globally the attacks getting more and more severe, and in the past cybercrime, certainly ransomware, was all about locking down companies or getting ransom money out of it. What we see right now is that more and more of these attacks, and certainly with ransomware, is that these attackers or these criminals are even pushing data during the ransom actually to the internet, shaming these companies, forcing them to pay up for the ransom, and is getting more and more aggressively. So the data leakage of these ransomware is growing significantly. Even in hospitals, even in the corona status as it is right now, we see a lot of impact also on healthcare. So it is getting very, very aggressive, and we have not seen the end yet. Also, the commercial impact versus the rights of the subjects. Existing social media platforms, we have discussed it, or we talked about it. The Facebook case, Schrems on the European side, has been very important. And just a few weeks ago, we have seen also some new platforms popping up. Also on the internet, TikTok, just name it, and Clubhouse is for example is one of the newest platforms right now in a sort of launching stage, specifically for Apple users. But we have seen already some data breaches in the Clubhouse, and it looks like they didn't take care too much, even in the early stages of data privacy. And for example, if you join or can join, it's by invitation only right now, Clubhouse, the first thing that actually Clubhouse does is actually discovering and copying your contact data into the system. So we have not seen the end yet, and there were some privacy issues in Clubhouse before, allowing to record some sessions or getting illegal access to chats. So also on that level, it's pretty amazing that launching a new social media platform is not taking care of privacy. They will get busted for very likely if they don't take care of it with the official launch. So the pressure on these companies is getting higher, even on an international level. So that's very important. Also very important, take back privacy. We see that lots of people getting conscious about this privacy. They care more about their data, but the major problem here is certainly with the launch of internet a decade ago. privacy was not that important. So we see actually that lots of data is readily available, and taking back that privacy is a huge effort. And we see that the pressure on these technical companies hosting internet platforms or hosting social media is increasing. So that's an important wave that we see right now, is that people getting conscious about it, claiming back their right on privacy, claiming back on control on their own data. And that's not that easy to achieve for the next coming years. Good.
Right, and I would just add that it's also gotten to be a big issue right now because of work from home or remote working. There's a lot more targeting going on individual levels as well. One recent trend is the theft of pennies at a time, is how they're referring to it, from bank accounts. So instead of it taking money from individuals, cleaning out their bank accounts completely, cyber criminals are now going to this individualized approach where they're getting into your system, getting into your bank, and only taking out small amounts of money over time. And it adds up to a lot of money, of course, when you accumulate it globally. But that's also part of the privacy risk. Working from home means your attention to your privacy and your protection of your private information maybe is not as diligent as it should be.
Yeah, one of the new things because of taking back that privacy is the cookie management. We will see that right now people start worrying about the tracking that is enabled by this cookie. We've seen lots of ways of working with cookies, and even on European level that there have been even some contradictory advices on multiple companies. So in that sense, handling this cookie wall stuff is very important. And what I meant, for example, here with the dark patterns is the big buttons with the accept all, which means opening up all the cookies. But in essence, if you care about your privacy, you should actually look at the smaller buttons and then tune your cookie acceptance, or actually ignore all, but you then also know that some of the parts of the platform might not also work in the way you would expect in that sense. And that's something that actually is getting very active, and we will see more and more companies to find the right balance in accepting no cookies while keeping the platforms alive. So that's also very important. And while in 2016 with the launch of GDPR, there was a lot of discussion in how direct marketing would be kept alive. We've seen actually very limited impact in that sense, but we realize right now that lots of these direct marketing companies have an awful lot of data of us, and which is called the data broker, is collecting all the data. The position of that one is becoming very important because of the discussions we had with the consent and the legitimate interest. We see a lot of companies popping up that are sitting on a large volume of data, and we see also on the European level lots of companies getting attention with that one, and not always positive attention in that sense. And one other important thing is also very important in the perspective of the session of today is data brokers that are not actually having their services or their data being stored in Europe. There are quite some companies that are hosting the services out of the US or Canada. And it's very difficult as a European subject, for example, to get in reach or to get contact with these companies, because actually they are officially being hosted in the US. So there's a lot of discussion over there, and I think that we will see more things popping up on this one the next few weeks, if not months. Good. Last but not least, also IoT. And as I mentioned, a few regulations and laws coming up right now because of the Cyber Act, for example, is we are all getting used to the IoT, so the Internet of Things. So lots of personal devices connected. I'm not talking about phones, but watches, fridges, toys, cars, even cameras, actually, that are directly connected to the internet, and who can be attacked. And even if I'm not mistaken, in the early 2017, we already had an internet attack on the DNS system by these IoT devices. So you will see that also that this is another area where actually we will see a lot of investments also in security, because they have our data. by design right now very low protection levels. And we will see that also regulations will have a look at this. And for example, in Europe, the demands for having IoT devices secured will only increase. So have an eye on that one. Again, maybe a very interesting topic for one of the next sessions this year with PCB. Go.
And I strongly recommend making sure you keep your IoT devices up to date. I just got updates on a few of mine that included two-factor authentication being added to them. So it is possible to upgrade them and make them more secure. So that is happening. So I think we've covered everything in our topic, and I see we're a bit over time, but we do have some reference material attached as well to this slideshow, and there's a link here, of course, provided for this by Peter. And there's some extra slides at the end of this slideshow as well.
Cool, Albana, it's up to you.
Thank you, Peter and Tony, for delivering this very informative and detailed webinar. PCB offers training and certification courses, which will show your dedication in implementing and managing privacy-related frameworks. And most importantly, you will get recognized worldwide. Now, before moving on with the Q&A session, I want to inform you that in addition to all available PCB training course delivery formats, PCB is now offering the ISO 27001 Lead Implementer and ISO 31000 Risk Manager e-learning training courses in English. Now we'll go ahead and take some time to answer some of the questions from the attendees regarding today's topic. Please note that due to time limitations, today our presenters will answer 2 to 3 questions. However, like in the previous sessions, we'll make sure to send you the link where you can find all answers to your questions during the live session. The first question is, considering the increased number of standards and regulations addressing privacy, wouldn't the adoption of a global standard that covers mostly all compliance requirements and commonalities help global organizations, as well as a guidance for countries with no existing privacy legislation? Wouldn't ISO 27701 be a good candidate for such an umbrella standard? And what would be the blocking points for such an approach? Peter, Tony?
Yeah, the ideal standard would be very interesting exactly to make a global standard. But by the way, the 27701, which was also called PIMS, does exactly that. So it's an integration of the GDPR way of working, but also be aware that the ISO standard is not GDPR only. So there is also a very strong reference to the NIST interpretation of PII, as Tony discussed early on. So yes, absolutely, the 27701 would be an ideal standard. Be aware that the 27701 and also the 27001, which is the ISMS standard, is a management system. So it's covering the processes, and it does not cover, for example, the technical standards like the common criteria, for example, is doing. So the IoT security, the hardware security, is not covered by the ISMS or the PIMS system. But yes, absolutely, you could use the PIMS or ISMS system as a global standard. As we discussed also in the previous sessions, you can easily plug in some other standards like the NIST or the Canadian rules on that one. So it's an open standard. It's not too detailed, but it allows you to plug in local technical standards if you wish to do so. So we're on the road on that one, on implementing that one right now. The fact is that the audit companies, which is the assessment companies, are getting ready for certification on that one. So on ISO level, the certification for the ISO 27701 is getting up to speed. On the other hand, GDPR certification as such and very strictly interpreting the GDPR is absolutely not ready for certification right now. So there's a lot of certification discussions going on. I think that even in that level, the Cyber Act will even surpass the GDPR on the level of certification. So getting certification as recognized by GDPR is very difficult. And you might also see, as we discussed in previous sessions, that there are some roadblockers in the legal part of GDPR that will allow actually certification under GDPR, because GDPR is not looking at an information security management system as certification, and that's exactly the difficult way to getting official GDPR certification on that one. So that's also another hot discussion which is not finished yet.
Okay, thank you, Peter. The next question is the separate legislation for health data, considering that health is under the jurisdiction of the Canadian provinces?
Yeah, so the way that health data is handled in Canada, it is handled at the provincial level. And even during this pandemic, the federal government hasn't been actively enforcing things like health restrictions or health guidance at the provincial level. That's left to each province within Canada to establish those guidelines and those enforcements. So it's the same with the personal health information and the guidance around that. It's left to the provincial level. I would like to see a national guidance built for that, however, for health information and the protection of it. I think I'll be waiting a long time before I ever see that happen. It has happened in the States with HIPAA, but it's nothing like that in Canada yet.
Okay, thank you, Tony. And the last question is, how is Brexit impacting GDPR and cross-border data storage?
Well, there is quite a recent discussion on the adequacy for the UK. It's quite amazing that at the start of GDPR we had the same adequacy decision for Switzerland. I think, if I'm not mistaken, it took 3 pages to get a decision. Now the UK leaving Europe is a page. I think if the document on the adequacy decision on the UK is 88 pages, so that also puts a very important emphasis actually on the implementation. Although the system is pretty much the same, there has been quite a lengthy discussion on getting the acceptance of the UK system right now as applicable for GDPR. So in that sense, it's considered right now as adequate to do so. But again, keep in mind that an adequacy decision in GDPR is a 2-year decision. And we had pretty similar discussions also on the framework like Privacy Shield with the US. So it's up to evaluation every 2 years. So that will very likely also happen for the UK. So for right now, is considered adequate as what the GDPR has been implementing. It can change over time depending on what the UK will do, depending on the regulations. Will they change or not? And it can be even political discussions or end up as a political discussion, as we have seen with the change of president in the US. It can change. It can same way it can change in the UK depending on the elections. We don't know, or if we have some other global events popping up, these might impact the decisions on GDPR.
Okay, once again, thank you, Peter and Tony, for this remarkable session, and thank you everyone for attending today's webinar. Please be informed that this session will be recorded and posted on our website and YouTube channel, along with the slides of the presentation. For more information about our webinars, please visit our website, www.pecb.com. Thank you all and stay safe.